So an important part of preparing our students for practice is teaching them about the values of the legal profession. And every professor teaching in every subject matter area can do that. But how can that happen? One answer may be the casebook that you already use. So each of these casebooks is written for a specific doctrinal area, but all of them have professionalism issues in them. And if we can find those issues, we can help better prepare our students for practice in every class. So today I'm going to give you some tips for finding those issues in your casebook and making them a part of your class, no matter what you teach. So when we talk about integrating professionalism into the curriculum, most of you groan and say, you want me to teach professional conduct rules. And I do, that is part of it. That's an important value of the profession, but there's more than that. Another value of the profession is serving our clients. We're fiduciaries, we owe our clients duties of competent representation and loyal representation, but students don't always understand what that means. And so it's important for them to get an understanding from us in every class. So that's another value. And then finally, there's some key traits and values that serve attorneys well in practice, like a good work ethic, being able to cooperate with other people, including opposing counsel. And these are things that we can talk about using cases in our casebooks. And I'll give you some examples of all of these today. So where do we start? The first thing we do is find the lawyers. And sometimes that's really easy because the lawyers are named in the court's opinions in your casebook. But even if the attorneys aren't named, we know they're there. Attorneys are involved in all of our cases. And when we find the attorneys, we can find the professionalism challenges that they face. And they come in each of those areas that we just talked about: professional conduct issues, being a good, competent, loyal attorney, and also just exhibiting values that are consistent with being a good lawyer. So when we find the lawyers, we find the lessons, and we can incorporate them seamlessly into every case. It doesn't have to take away from the doctrine that you're trying to teach. It's just part of every class, and the students, after a while, stop thinking you're doing something weird when you start talking about these issues. Another important thing about finding the lawyers is you have to make them relatable and human to your students. If the attorney makes a mistake, and sometimes they do, we don't want the students to think, this is just a bad person and this couldn't happen to me. We want the students to be able to identify with the lawyer. So how do you do that? I mean, sometimes it's telling them, this is something that happens frequently in this area, like this kind of mistake. This is something I've seen before. And I don't like this one very much, but sometimes I have to say, I did this in practice, I made this mistake. And students start thinking, oh, this could happen to me, I guess I can pay attention and learn something from this issue in this case. So first I want to talk about the value of fulfilling duties to our clients. And it's important to understand what some students think a lawyer is. Some of them picture a lawyer being a hired gun, with a singular focus of achieving the client's goals. And we can help them understand that lawyers exercise judgment. Lawyers are more than a hired gun, and it's complicated to provide competent, loyal representation. So we can give them examples of this in all of our casebooks. One context for this is the lawyer as advisor. So sometimes your case will involve a legal issue that the client has received advice about before the matter turned into litigation. And so, for example, in this case, the attorney in the case actually testified about the legal advice that he gave to his clients. We're not going to see that in every case, but we'll often see a case where an attorney was involved beforehand and gave some advice. So when this occurs, you can ask students to talk about the case from the perspective of the advisor instead of the perspective of the opinion after years of litigation. So questions like, what facts did the lawyer need to gather to give advice to this client? What legal research do you think this lawyer did? Did the lawyer understand the potential for liability for this client? Maybe understand the potential for this very litigation? And what did the lawyer explain to the client? When we start asking these questions, students understand there is some judgment involved in being a lawyer, and sometimes a good advisor advises against conduct. And I hope that that's a lesson that students get from talking about the lawyer as advisor. In the same topic of fulfilling obligations to clients, every case obviously has lawyers involved in litigation, and this can be a positive thing to talk to your students about. If you are moved by an example of good lawyering in a case, no matter what your class is that you're teaching, you can point it out. Maybe it was a creative argument that an attorney made to frame an issue. Maybe it was just a good, smart, strategic move. Maybe they asked for a bifurcated trial. No matter what class you're teaching, you can talk about those things. You know, we have good examples of zealous advocacy in the cases that make it into our case books, and students are interested in hearing about that. Sometimes the examples are not so good, and this is, and I can tell some of you are reading it already. This is a case that I like to use as a not so good example. The defendant in this case testified, well, he gave a deposition, and there's reason to believe he was kind of a difficult witness. When he was asked why he voted to expel the plaintiffs from the company that he was an owner in, he explained that it was because he had Wheaties for breakfast that morning, and he didn't need to have a reason. So we can use examples like this to ask students questions like, do you think that the client in this situation understood what the legal issues were in the case? Was he prepared for his deposition? Did he know that his good faith was an issue in voting to expel these people from the company? Did he have someone tell him that depositions can be read into the record at trial? I think the answer is he probably didn't understand the purpose of his deposition. And I hope that my students, when they go into practice, remember this as a really memorable example of why you have to prepare your clients for their deposition. Now, I know this is the one some of you dread. It's the professional conduct rules. In practice, attorneys can't say professional conduct rules are not my area of practice. It's everyone's obligation to understand these rules, and professors should be no different. So when we see these issues come up in cases, we should talk about them. So for example, this is from a business association's textbook, and the attorney in this case had a conflict of interest, but he didn't withdraw until he was pressed to do it by his opposing counsel. So when we see an example like that, you know, I ask students to research the professional conduct rule of the jurisdiction, not the model rules, the actual professional conduct rule, and then analyze why was this a conflict in this case, or why did it violate a rule. They sometimes think that that sounds like professional responsibility, but I remind them every lawyer has to do that. It doesn't matter what class you're in. Another thing that we can do when an issue like this comes up is talk about why. Explain to them this attorney was representing small business owners and a small business, and conflicts of interest are frequent in this context. And that helps them understand this could happen to them if they're not diligent about dealing with these issues in practice. So again, it's making the lawyer relatable, not a bad guy. It's something that could happen to the student. Finally, the values that really serve lawyers well in practice. I think hard work and cooperation are two easy ones that you can stress using case law. I'm going to talk about cooperation specifically with opposing counsel. We have lots of examples of this in our case books, good examples and bad examples, so it's a good one to use for that reason. And it's also a good one to talk about because students often don't understand it. Students think that they need to fight with opposing counsel, and they can't understand why you could possibly want to cooperate with somebody. So we try to incorporate examples that show how cooperation serves a client well, or how lack of cooperation might be bad for the client. So in my civil procedure class, I return to the topic of cooperation with every case during discovery because it's really easy to understand how cooperation can actually help a client in that context, or a lack of cooperation can hurt a client. Just another example from another textbook, in this case, the losing party asked the Second Circuit for an expedited appeal and was denied. And then we see that opposing attorneys were able to enter a stipulation that resulted in a final judgment in the case and the right to an immediate appeal. So obviously, both of these parties thought this was in the interest of their clients, but they wouldn't have been able to do it if they couldn't cooperate. And even though that only takes a couple of minutes to explain in class, I think that's good for students to hear that and think about what happened in this case and why was cooperation good for their clients. So in conclusion, we can all teach professional values. We can use our case books. We just have to rethink how we use them. And if we find the lawyers in the cases and find the professionalism challenges that they face, we can better prepare our students for practice.